Okay, so the regulations are directly applicable because they are provided as such in the founding treaties. This means, as we have said, that the regulations cannot be transformed or transposed into the national legal systems of the member states because they aim for uniformity. Therefore, when the European Union wants a subject matter to be uniform in 28 member states, then it shall adopt a regulation. What happens if a member state transforms a regulation into its national law? What if a member state transforms a regulation into its national law?
Is it invalid?
This is the question. What is it then? Yes, Deniz?
I think it would not be invalid because they can do such transformations to apply that regulation
Can they?
more effectively, but it would not mean that it is not directly applicable.
At the first instance, can they do such transformation?
No.
They can't. What if they transform? Yes, Deniz?
It may result in disharmony because the aim was to provide the conformity.
Yes, but before disharmony, this would be infringement of EU law, because it is the founding treaties that provides that the regulation cannot be transformed into the national laws of the member states. This was the subject of Vairola case of 1973, speaking about non-transformation of regulations under the founding treaties. In the Vairola case, the Court of Justice provided that the regulations bind all the member states and they have the force of law in their territories without the need of transformation into the national laws. Transformation of according to the court, transformation of a regulation might constitute infringement of EU law since it changes the nature of regulation, which might bring changes and undermine the uniform application of EU regulation. Therefore, according to the court, since the regulations aim for uniform application of EU law, transformation of a regulation might be equal to infringement of European Union law. Therefore, an inaction for infringement might be taken against that member state which transforms a regulation into its national law. The regulations might be enacted by the Council and the Parliament according to the ordinary legislative procedure, or by the Council alone, or by the Commission alone. They come into force either on the date specified in them. In the last provisions of regulations, usually there is a provision providing for a date on coming into force of that regulation, or if there is no such date, on the 20th day following the publication of that regulation in the official journal of the European Union. Therefore, a regulation may provide for a date, a specific date to come into force, or if there is no such date, then on the 20th day following its publication in the official journal of the European Union, official journal of the EU in Turkish, Avrupa Birliği Resmi Gazetesi. And lastly, the provisions or certain provisions of a regulation might be directly effective. Certain provisions of a regulation might be directly effective. In this class, direct applicability and direct effect are two different characteristics, okay? Please make sure that you know the differences between them. Direct applicability, when we speak about direct applicability, what do we mean?
There is no need for transformation or transposition.
Exactly. This is a characteristic of EU regulations. This is a characteristic of the instrument itself. It is directly applicable, meaning it does not require transformation into national law. But when we speak about direct effect, in Turkish direct effect, doğrudan etki, we speak about the provision itself. There is no list of provisions which are directly effective. We do not know a priori what the directly effective provisions are. Okay, this depends on decisions of the Court of Justice. Therefore, eventually, the Court of Justice decides which provisions of a regulation are directly effective. Okay. What is the importance of direct effect?
It can be claimed before the national court.
If a provision of a regulation, it is the same about direct effect, what we spoke about as regards the founding treaties. If a provision is directly effective, then an individual can claim his rights before the national courts, based on that directly effective EU provision, okay? Therefore, directly effective provisions gives rights to individuals that can be claimed before the national courts. The directly effective provisions of EU regulations, the directly effective provisions of EU regulations give rights to individuals that can be claimed before the national courts. Therefore, an individual may, or the rights of the individuals may arise from national law and EU law if
it's directly effective.
that EU provision is directly effective. Okay? Then comes the question of which EU provisions are directly effective. Which provisions in the regulations now are directly effective? It is the same. It's the same criteria that will apply here as the founding treaties. Yes, Deniz?
We spoke about last week, which are precise, clear, and unconditional according to Court of Justice.
Exactly. If a provision is clear, precise, and unconditional, we said that this is a directly effective provision. It is the same here. What we spoke about the founding treaties also apply here, that a provision in a regulation is directly effective if it's clear, precise, and unconditional. And if it's clear, precise, and unconditional, it is directly effective. If it's directly effective, then an individual may claim his rights based on that provision in that regulation before the national courts. Okay? Please make sure that in the early decisions of the Court of Justice, for example, in Van Genen laws, in cont'd and in Smental, the European Court of Justice, even the European Court of Justice, used direct applicability and direct effect interchangeably to mean direct effect. But today, we make this differentiation between direct applicability and direct effect. All right? For example, the founding treaties are not directly applicable, but but certain provisions of founding treaties
Direct effect.
may be directly effective. We are 100% sure about direct applicability, but we always speak about a possibility for direct effect. It may be directly effective. We may not know at the moment. Who will know? Who will tell this? The Court of Justice. First, we had to ask to the Court of Justice whether a provision is directly effective or not. If, of course, it was not decided by the court beforehand. All right? Good. Let's move to directives.
May I ask a question?
Yes.
So can we say that the European Union differs from the other international agreements in this sense? Because in the other international agreements there is no private enforcement like this. I mean, individuals cannot generally claim their rights from international agreements. So can we say the difference?
Of course, this is one of the most important things about European Union law. The European Union law, I think we have mentioned this at the beginning, it not only provides, and we will be mentioning it again when we speak about cont'd decision, it is provided by the European Court of Justice in the early times of European integration, starting from Van Genen Law's case. You will read about this case in the book chapters as well, and we will have a presentation about cont'd case, which follows Van Genen laws. Their European Court of Justice also says that this is a new legal system, the European Union law, and it not only provides rights and obligations for the parties, meaning the member states, but also for the individuals. Therefore, the individuals will have certain rights arising from European Union law, sometimes directly, sometimes indirectly. When the treaties provide obligations for the member states, this may also refer rights to individuals, okay? Or sometimes the rights are provided directly by the European Union law. Therefore, we will speak about that, but you are right by saying that the individual in EU law is at the center of the system, not like other international agreements, which usually provide rights and obligations for the contracting parties only, okay? But then this does not mean that European Union law has its law enforcement agencies. This is something else. You did not mean this, did you?
I meant private enforcement.
The enforcement of, the individuals that have the ability to claim their rights before the courts. But if the rights of the individuals are not implemented, okay, there is no agency in the European Union to force for the implementation. Law enforcement agencies in Turkish, icra makamı. There is no specific institution in the European Union to enforce that right. But you are right that the individual may go to the national court to ask for certain rights arising from EU law. Okay. Now let's move to directives. What is that in Turkish, a directive? Direktif veya yönerge, ama yönetmelik değil arkadaşlar, yönetmelik değil. Direktif veya yönerge tercümesinin kullanılmasını teşvik ediyoruz. Ben daha çok direktif olarak kullanıyorum Türkçe derslerde. Okay. Has anybody read about directives? Deniz?
They are not binding in its entirety because member states can choose the method or the form. Also, they can have general application, but also they can be addressed to some member states, and they are not directly applicable.
Yes, see, when you read, you remember certain things in class, of course. EU law is not difficult anymore when you read at home. Yes, directives are different than regulations. They are provided under Article 288 again, under paragraph 3. 288, paragraph 3 of the Treaty on the Functioning of the EU. According to that provision, a directive shall be binding as to the result to be achieved, upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and method. But shall leave to national authorities the choice of form and method. Which characteristics would you infer from this provision of the founding treaty, Article 288, paragraph 3? Which characteristics of a directive can we understand from this provision? Yes, Meliha?
What?
What's your name?
Nadide.
Nadide. Ah, it's someone else. Okay. Nadide. It's from the other class. Yes.
Like regulations are like general application. It applies to every member state.
Does it say so?
No, it doesn't.
What does it say?
It says to the result to be achieved.
It shall be binding as to the result to be achieved. It continues. Upon each member state to which it is addressed. Eylül? Sunus? Yes.
They are not directly applicable, so the state must transform.
How do you understand?
Because it says that shall leave to the national authorities the choice of form and method. So the state will choose, not choose to transform, but I think they have to transform it, but it's not directly applicable.
So they have to transform it, you understand?
They have to.
But where do they have the choice? To choose the form and method on transformation of a directive. So is the directive anyways binding? It is for sure binding. It is a binding source of EU law. It is binding. Is it binding for every member state?
No.
Why not?
Because it says upon each member state, which is addressed.
So may it address all the member states? Yes. If it addresses all the member states, then it is binding for all the member states. But it may address certain member states, okay? So this is one difference with regulations. A directive is also binding, but it may address certain member states. It is not like regulations. When we speak about regulations, we said that a regulation is binding for all the member states, and it is not possible to address certain member states with a regulation. This is difference with a directive. Therefore, a directive is binding as to the result to be achieved. We will come to that, but it is binding for the member states that it addresses. Sometimes all the member states, sometimes certain member states. Why is it so? Why is there a possibility that with a directive we can address certain member states? Yes, Deniz?
Because maybe in other member states there is no need for that result.
Exactly.
It is already there.
Because the aim of a directive is not uniformity, it is harmonization or approximation. When you have the aim of uniformity, you want to make that area exactly the same, 100% same, okay? There is no such aim in directives. If there is a need to harmonize the legal systems of 3 member states, then it is sufficient to adopt a directive rather than a regulation to harmonize that area. All right? But a directive is binding for those member states as to the result to be achieved, okay? The objective, substantially, it is binding for the member states. But where does the member state have a choice is to choose the form and method to transform a directive into its national law. Therefore, first, directives are not directly applicable, because they need to be transformed into the national laws of the member states. Second, it depends on the national law of member states on how to transform a directive into the national law. They have discretion to choose the form, meaning, yes, they have the discretion, but to choose the form, meaning, form?
Like the way of ratification, transposition.
Like?
Maybe law, it may be
Referendum.
lower than law.
That can be an act of parliament, provided in an act of parliament. It can be provided in the constitution. It may be provided in a regulation in the national legal system. Therefore, the member state has discretion to choose the form of that instrument. And secondly, it has the possibility also to choose the method, meaning approval of the parliament, or as an administrative instrument, or going to the referendum to transform a directive into the national law. All right? Therefore, they are binding as to the result to be achieved upon the member states to which they address. They are not directly applicable, and are they directly effective? Or are the provisions of directives directly effective? Yes, Deniz?
I read it in the book, but I didn't understand clearly, but I can say something. Yes, according to the book, yes, they are directly effective, but they have horizontal direct
we will not speak about that.
So I couldn't differentiate between
vertical and horizontal direct effect. Okay. I think we have one court decision about horizontal and vertical direct effect. We will speak about that. Well, we will not go into detail at the moment. It is sufficient if you tell now that
but they are directly effective, yeah.
If the provision is clear, precise, and unconditional. Therefore, the same 3 criteria would apply. We will discuss important decisions on the direct effect of directives as well. The directives can be enacted by the Council and the Parliament together, by the Council, or by the Commission. If they address all the member states, then they come into force like regulations, meaning either on the date specified in them, or if there is no such date, on the 20th day following their publication in the official journal of the European Union. If they address certain member states, then they come into force with notification. Notification, bildirim. Then we have decisions. Yes.
We said that the national authorities have the right to choose the form, and let's say that the directive's form is the directive here too in the national system, and then there is a regulation that is the opposite of the EU directive.
This is not possible.
It's not possible. Okay.
Because the member state cannot change the substance of a directive.
No, they transformed it as a directive, but the national legislator
Cannot change the substance.
They're not changing the substance. They're just, for example, creating a law, but the content of the law is the exact opposite of the directive of the EU.
That is not possible. You will see. This is not. If it does, it is possible, then this would be infringement of EU law.
Okay.
Okay? A member state, you will be seeing later. If there is a directly effective provision of EU law, which is contrary with national law, or when there is a national legislation, which is contrary to a directly effective EU provision, then you know the answer. EU law prevails. This is the principle of supremacy or primacy of EU law. We will be speaking about that as well. Costa Enal is about supremacy of European Union law. Okay? This is an obligation that arises from the founding treaties, from the decisions of the Court of Justice, supremacy of EU law. And this would be therefore infringement of European Union law.
What if the law was before the directive?
It does not matter. Under Cimental case, European Union law always prevails, independent from the fact that the national law was enacted after European Union law. Okay? Therefore, lex posterior principle does not apply in EU law. Okay? Even if national legislation was adopted after European Union instrument, still EU law prevails as long as the EU provision is directly effective. We will be seeing that too. All right? Yes, Umut.
So it is not a must to transform such a directive into national law?
It is always a must. We will have, who will be speaking about Frankovic case? Yes, this is a very important decision of the Court of Justice. If a member state fails to transform an EU instrument into its national law, we will see what happens.
But it can be rejected by the referendum in another procedure.
No. Then the member state has to adopt a reliable form and method for transforming the directives. Because normally the EU doesn't, okay, when you compare the adoption of regulations and directives in European Union law, directive is, I would say, the default instrument, not the regulation. Because when the EU adopts regulation, then it wants everything uniform in the EU. This is not the case in all areas. So directives are mostly adopted more than regulations, I would say. So that member state has to find sufficient means to transform a directive into its national law. Of course, you wouldn't ask to, maybe it wouldn't be very wise to ask everything to the public, because you have to take into consideration the possibility of rejection by the people.
So such a nation state, such a state would consider another application.
Exactly, another form and method for transforming a directive into national law.
Time period, it is still applicable due to.
Yes, you will see. No worries. There is usually 2 years period for its transformation. We will see what happens if a member state does not obey this 2 years period. We will see what happens in that 2 years period too. All right? I'm now trying to give you a good legal basis for our further discussions in class. All right? for your inputs as well, for your presentations too. Okay, the decisions are also binding. They are also provided under Article 288, paragraph 4 of the Treaty on the Functioning of the EU. According to the treaties, a decision shall be binding in its entirety. A decision which specifies those to whom it is addressed shall be binding only on them. Therefore, a decision is also a binding instrument of EU law. It may address the member state or a member state or an EU citizen and then shall be binding only on those. Again, it may be adopted by the Council alone, by the Council and the Parliament together, or by the Commission alone. It comes into force like regulations if they address all the member states and adopted under ordinary legislative procedure. If not, they come into force by notification. Again, for direct effect, we apply the same three criteria for decisions as well. Okay, these are important regulations, directives, decisions. Please also read from your chapters, okay? Now let's move to international agreements. Sorry, let's move first to recommendations and opinions, very short. Recommendations and opinions. The treaties themselves give the power to certain institutions to issue recommendations and opinions. For example, in certain articles of the founding treaties, you would find this power of the European Commission or Economic and Social Committee. The Commission has the power to issue recommendations and opinions. The Economic and Social Committee, the Committee of the Regions as well, have the power to issue opinions. These are non-binding instruments of EU law. This is also provided under Article 288, paragraph 5 of the Treaty on the Functioning of the EU. Therefore, they are not considered as a part of EU legislation in the strict sense, but they are considered as sources of EU law. Therefore, these are not legislative acts of the EU. Now let's move to international agreements as sources of EU law. When I say international agreements, what do you think of? Which international agreements do you understand? Yes?
Agreements between the EU and another third country.
Okay, this would be the first group of, we will come to that, agreements. When we say international agreements, the EU versus a third country, or the EU versus an international organization. What else?
Between EU member states?
The agreements between the EU member states. Between the member states and the third parties. Do you think of the founding treaties? Do you think of amending treaties or accession treaties? Aren't they also international agreements? Do you understand those as well? Why not? No. So do we consider them also as international agreements here? As secondary sources? No. No? Why not?
They are primary sources.
Here, when we say international agreements, we do not mean those. Founding treaties, amending treaties, accession treaties. Of course, there are international agreements as well, because they are signed between the member states, they are signed between states or organizations. Of course, international agreements in very general terms. But in European Union law classes, we do not consider them as international agreements. Now, we have considered them as primary sources of EU law. But now, we deal with, under the heading of international agreements, we deal with certain other agreements as sources of European Union law. All right? Because when we speak international, when I say international agreements in class, some students used to think about founding treaties as well. No, not now. We have already spoken about founding treaties, and yes, we know that they are also between the member states, so there are international agreements in very general terms, but not in European Union law classes. All right? When we speak about international agreements, there is a possibility to think about different types of international agreements, but I merely mean 4 different types of international agreements. First is, as we have stated, the international agreements between the European Union and a third country or an international organization. A third country or an international organization. Tell me how and why the EU can negotiate an international agreement with a third country. Or how would it be possible for the European Union to negotiate and conclude an international agreement with a third country or international organization? You all know the answer. Everybody knows in this class. Tell me, in which situations there is a possibility of the European Union to negotiate that agreement and conclude that agreement alone with the third country and not with the involvement of the member states? How could this be possible legally? Or when is it possible? Yes, Eylül?
When its competence is exclusive.
Exactly. The European Union can negotiate and conclude these international agreements with third countries, or has to also negotiate, conclude these agreements by itself without the involvement of the member states when its competence is exclusive. In such situations, we speak about exclusive external competence of the European Union. Exclusive external competence of the European Union. In Turkish, münhasır dış yetki. We spoke about this possibility when we spoke about the competences of the European Union. In which areas there is exclusive competence for the EU? In 5 areas, right? Customs union, monetary policy for the Eurozone countries, common commercial policy, preservation of marine biological resources, for the under the common fisheries policy, and no, and fifth area is, we've said that.
Movement of goods.
No,
Security.
no. Yes, establishing of the competition rules necessary for the functioning of the internal market. Therefore, in the 5 areas, the competence of the European Union is exclusive. How do we know? The founding treaties provide for these areas of exclusive competence. It is a closed list, cannot be enlarged. Numerous clauses applies in these 5 areas, as we have said. True? Yes. So, when the EU's competence is exclusive in an area, as we stated, it's both internally and externally exclusive. Internally exclusive means within the European Union, meaning
It's exclusive in domestic policy.
what does it mean? The EU adopts binding rules for the member states within the EU territory. It is also binding externally means when there is an international agreement to be negotiated and concluded, it shall be done by the European Union, it means, okay? Therefore, when we read, for example, that international agreement is concluded by the EU and a third country, we understand that this is an area of exclusive competence, exclusive EU competence, okay? In such a case, who will negotiate this agreement on behalf of the European Union? The Commission. Who will conclude?
Council.
The Council. Therefore, it will be like that. On one part of the table for negotiation, it will be the representative of the European Commission that will negotiate that agreement with the other party sitting at the other side of the table. All right? This is the first, these agreements are the first type of agreements, international agreements that we understand as a source of European Union law. All right. We will continue on Friday with the sources of EU law.